Okay, this is cause numbers 22-39100 and 22-39101. Are you Letitia Tebow? And Ms. Tebow is currently on probation for failure to comply with sex offender registration in each of these cases. I looked this up. I think there may be, and Ms. Simon's here, this update report says 2 10-year adjudicated probations, but it was a 2-year term.
It was 2 over 5.
2 TDC over 5, correct?
Excuse me, that's where that was in there.
Okay, just making sure. And so Ms. Tebow was previously here, entered pleas of true to counts 2 and 4 in the motion to revoke probation. And I've received the updated pre-sentence report. Have you all received that updated report?
Defense has done.
State has to.
Any additions or corrections to that other than the one that I already made?
None from the state.
Nothing but that.
And there was no agreement. Is there any evidence with regard to the other counts, Mr. Hoffpower?
Any new failed to register.
No. I don't know. She pled true to counts 2 and 4, so there's
Correct.
obviously some other counts. Do you have any witnesses or evidence with regard to those other counts?
We're going to full abandon those counts. We'll just proceed on 2 and 4.
Okay.
Other than I call my probation officer, but I like her opinion.
Okay, so I guess there was an arrest in
It's in Florida.
Palatka, Florida. Okay. Hold on a second. Let me get
Putnam County.
Okay, so count 1. Why don't you have any evidence with regard to count 1 if your probation officer's here?
We can call. I'm sorry. Apologize, Your Honor.
Ma'am, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You may proceed.
Ms. would you please take the name from the record, please?
Sarah Simon.
Ms. Simon, are you the probation officer assigned to Ms. Tebow?
I am.
Okay, and how long have you been first supervision officer?
Year and a half.
Okay, and throughout the time that you've been a probation officer, has you complied with the terms of other conditions? In either one of the cases?
Speak up, please. I'm sorry.
Okay, no, she has not?
She's not.
Yeah, okay, in what instances has she not complied?
Steve-O has had consistent reporting habits. She was not paid towards her processed fees. And she eventually committed 2
Was she allowed, first of all, was she allowed through her probation in Texas to venture out of the state and be in Florida?
She did not.
Okay, she wasn't allowed?
She was not allowed.
Is she allowed through her reporting as a sex offender to move or go to another state without no probation? Is she allowed to leave the state?
Not without.
She pled true to that. Count 1 is that she has not reported since January 27th of 2025.
Is that true now? Is
That is true.
she intermittently or she is fully not? She's been called absconder.
She is absconded.
Okay, since that day.
Yes. Or 90 days after that comes in January, she becomes absconded.
She's been absconder. Okay, and since she reported since the time on which she was arrested.
She has not reported
Have you spoken to her at the jail?
at the hearing.
Okay. All right, did she give a reason for why she didn't report?
She did not.
At this time, I'll pass it on to you.
Okay, I also would like to know, Ms. Simon, were you able to confirm in any way the arrest? Obviously, she's going to say she didn't do it, and that's okay, but if she was actually just, whether an arrest happened in Florida?
Yes, I did obtain an arrest report from Florida.
PC, okay. But do you have a problem cause? Do you have a full offense?
The full offense.
Okay, for what crime was she arrested for?
There's two. I think one was petite theft and then obstruction by disguise first.
Was it all the same incident?
Yes.
And what date did that occur, according to the law?
June 29th, 2025.
And were both those committed?
Objection as far as committed, Your Honor. I don't object to her listing evidence as far as an arrest.
An
As far
arrest.
as the actual commission, it could violate a right to front cross.
Did the allegation occur?
Yeah, the arrest.
The arrest occurred while she was on probation.
Kelly, this just did something again.
Correct.
And those haven't been resolved to your knowledge?
Not to my knowledge.
May I proceed, Your Honor?
Yes.
She initially failed to report in January, is that right, of 2025?
That was the last face-to-face contact I had.
January 2025. Then arrest June 29th of 2025.
Yes.
So February, March, April, May, June, 5 failures to report. And she went into absconder status March of 2025?
Maybe April.
April.
Like 90 days after.
90. So April 2025, she became an absconder. 2 months after that, she was arrested in Florida, is that right?
Right.
So you were aware if she was in Florida, which state, when were you made aware that she was in custody in
I
Florida?
received a phone call from somebody that let me know that she was arrested and in jail in Florida. And then that's when I received this arrest report.
So when did there was an MTRP entered into NCIC, I guess, after April? Was there an MTRP and that's why Florida advised you there was an active warrant for her then?
There was an active warrant for the interim. She was arrested for the,
Right, and that warrant popped up in June in Florida.
correct.
So from June 29th to today, she's been in custody, is that right? So
I
she
didn't try to
couldn't
open
report
anything, it just started doing stuff
to
on its
probation
own.
department. She's in custody from June 29th to today because she's locked up.
I don't care.
That's not her fault that she didn't report because she's in custody, correct? So she can't report.
Right.
As far as supervising her, she has reported, you say inconsistently, but that means she has reported some, correct?
Correct.
During the times that she has reported, have you been able to interact with her appropriately? She maintain proper demeanor, that type of thing?
She was, yes, but she was consistently late. I had to reschedule her several different times to get her into the office.
Have you had any other difficulties with her as far as just maybe perhaps being late with scheduling, as far as your actual interactions with her? Does she maintain appropriate demeanor, acted appropriately with you?
Yes.
Would you object to continuing to supervise her?
I would.
Why is that?
My personal opinion, I don't think it's too close to her probation as a priority. She has been on probation, I think, since 2022 and has made no progress in regards to her fees. She did some community service, and that's about it.
When you say progress, how do you measure progress on probation?
Satisfying her court order conditions.
And how has she fallen short other than the reporting and fees and community service?
That's it. And she committed.
So is this correct in the, hold on a second, hold on. Is in the updated report, it states that since she was granted supervision, has reported 6 times for scheduled office visits. Is that a correct number? Okay. 6 times since 2022.
I have another question, Your Honor.
Let's let Mr. Kindler finish.
If she were to be extended, which the court has the power to do, I mean, you would continue to supervise her, right? Or would you have a problem with supervising her?
I would work with her this.
See any indication of the need for some type of mental health referral or anything of that nature? I mean, I understand she's only reported 6 times, as the judge indicated. You see kind of programs or other things that probation could do for her to maybe perhaps to get her on the right track?
I think the only other option would be the cognitive justice.
Pass witness.
Your Honor, is this the first time that we've been here on these two cases for a motion to revoke?
No.
There was another time back in 2024 in which we had a hearing similar to this, not me, especially as the attorney, but she was brought in on a motion to revoke, and her probation was amended, and she was given 30 days in JCCL, and she was continued, and she was added to the mental health case.
The high meeting case, and she didn't report enough to be transferred over to the high meeting case.
So this is not even the first time that we've been here on this, on similar allegations. That was a year in 2024, we did the same deal. Is that correct?
I might follow up on that. I believe in the previous HURP, she had a motion, again, a motion to revoke. She had federal charges, is that right?
Correct.
The NTRP was filed after she received the federal charges,
I believe so, yes.
and she was housed in the cell unit. Were you supervising her then?
No, it's not.
Do you know if the detainer was placed on her for that NTRP while she was in federal custody?
I didn't know.
Did she actually do federal time while she was on probation for this case?
That is why the NTLB was dismissed.
So she received, I think, about a year sentence in federal court for misprision of felony. Is that consistent with what she did?
1 year federal probation.
Prison, she was locked up, right?
She got probation.
She had 1 year federal probation.
Probation, okay, for misprision? Or you don't know? What the offense was?
I thought it was a possession.
Okay. Anyway, she received a year of federal probation, so she was not revoked and was allowed to serve the probation concurrently.
Correct.
So during the period that she was on federal probation for that year, do you know if she was reporting to a federal probation officer, or was any issues with the federal probation that you're aware of?
According to the CBO, she successfully completed her federal probation.
And that was at the same time that she was on probation with Jefferson County.
Correct.
Was she reporting to you during that time period as well? What was her reporting record in Jefferson County during that period? I guess it was probably back in 2024.
Well, she's reported 6 whole times so obviously it wasn't great even when it was then.
Right. But she was being supervised at least during that period federally, was able to successfully complete that probation, correct? Does that indicate to you that perhaps she could successfully complete Jefferson County probation if she's sufficiently
She
motivated?
has the ability to, but whether or not she has the motivation or the want to do so.
Pass one, Jim.
All right, any other questions?
No, Your Honor.
All right, thank you, Ms. Simon. Any other witnesses?
No, Your Honor.
I would defer to Ms. Tebow, Your Honor, if she wanted to address the court. I think she has written to the court, and that letter's incorporated in the PSI.
I received it and read it. Anything else?
No, I mean, when I did fail to report it, sometimes I was hard with scheduling, but a lot of it had to do with my mother being sick, and I brought my mother sick to her office with me multiple times, because I wasn't able to just stay with where she was at. I brought her when I could. I mean, she's passed now, but at that time frame after,
But, I mean, we're talking about since 2022.
I was in
Or
a
20
federal facility for a year and a day.
Okay. All right, so here's the thing. I'm not even sure where this agreement came from and why I accepted it in the first place, because giving somebody the minimum of 2 on a probation, so I have really nothing to do hardly on this. But Ms. Tebow, I mean, you've been given every opportunity over the last 4 or 5 years to do everything you're supposed to on this probation, and you've refused to do that. You flat out refused, and we all have different issues that go along with parents and family members and things that go wrong. And instead of, I mean, it looks like, I think one of the things that concerns me the most is that you called June 2nd asking why the police went to your home. June 2nd you called. And so your probation officer said there's a warrant because of your violations on June 2nd. Then you went to Florida and got arrested for 2 new offenses without registering, without obviously telling anybody where you are and the type of probation you're on, the offense that you're on probation for. That's probably the number one thing that you should do. So flee in the state when you know that there is a warrant for your arrest. gives me no reason to leave you on probation. Unfortunately, I think for me and for the community, the most I can do is 2 years, and so that's what I'm going to do. I'm going to find, based on the evidence today, that counts 1 and 3 are true. So I'm going to find you entered your pleas of true to 2 and 4 freely and voluntarily, find all 4 counts true, find sufficient evidence to revoke your probation, and cause number 2239100, revoke your probation, sentence you to a term of 2 years in the institutional division of the Texas Department of Corrections. You do receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And cause number 2239101, also find sufficient evidence to revoke your probation, and at this time revoke your probation, sentence you to 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. You need to sign that, please. I'm handing you the trial court certification that shows there was no agreement. You do have some rights to appeal. You can talk to Mr. Kimler about that, and he'll give you a copy of that as soon as y'all get it signed. Thank you for being here.
Before we begin, I'll let you know what we've proposed to see.
Okay.
If you even go any further or not.
Okay.
We were here a couple weeks ago on Mr. Byerly. It's my understanding I had previously prepared for a hearing on those new offenses. At that time, the case was reset, so I did not have the officer subpoenaed for today. I can certainly get them if the court would like to hear from those. It's my understanding that he now intends to enter pleas of true to those new offenses. When we were here last, we had made the suggestion of ISF/SafeP. It came to my understanding that he's already gone to ISF, just from the reaction that the court kind of gave us to that, and in my extensive conversation with Ms. Johnson, we have taken that offer off the table and made an offer of 5 years in all 3 of the felony cases for a revocation, which would then make him a repeat offender if he's back.
Okay. And that's your understanding and your agreement as well, Mr. Burbank?
Yes, Your Honor, and we prepared paperwork and 3 indicated 2 MTRPs and new possession.
I only see 2. Is there another set of paperwork? I've got the 2 MTRPs. I don't see the new case.
Possession that I sent.
So we already went through those motions. I guess I just need to go through them again because there's going to be a change of plea.
3, 4, and 6, Your Honor.
Let me, if you'll print the second one, I'll print the first one. Let me get those pulled up real quick just to make it easier for me to go through. And we can print the ones that were already modified. That way I can make notations on that.
And Judge, just again, I know I had let you know last time, and I'm not meaning to interrupt you.
Go ahead,
While you're
just
reading,
praying.
obviously the concern of the original underlying offenses back in 2017 that carried on until 19 was the violation of protective order. I've continued to maintain contact with that family and can assure the court that they have assured me that there has been no issue with Mr. Byerly.
Good.
So
Thank you for
I just
that
want
as
the
well.
record to reflect that.
Okay. I'm getting there. Okay, so
Would it be better if I made an oral motion to withdraw previous?
nope, I'm just going to go back and I'm going to just rescind everything that we did at the previous hearing, and that way we start fresh from this hearing and there's no mistake on what everyone's agreement is and what he's pleading true to, and we'll do all of that today. So will he waive the formal reading of the motion and the indictment?
He will.
The motions. Okay. Mr. Byerly, in cause number 1828800, I have a first amended motion to revoke your unadjudicated probation. It shows that you were placed on probation May 13th of 2019 for the offense of violation of a protective order. That's a third-degree felony, and that was a 10-year deferred probation. Is that correct?
Correct.
And then in cause number 1829063, I also have a first amended motion to revoke your unadjudicated probation. Shows that you were placed on probation May 13th of 2019, also for violation of a protective order, a third-degree felony, and that was also a 10-year deferred probation. Is that also correct? And so it alleges that you violated your probation, and y'all are going to go,
1, 2, 3, 4, and 6.
okay. The new offense that he's about to plead is the possession, right?
Correct, that should be number 6.
That's 5.
Oh,
6 is that he possessed it. I mean, but 5 is committed the offense. So that would make
I'm
sense.
sorry, they're different numbers in each one.
Oh,
One is 6 and
great.
one is 5.
I love that when that happens.
If you want to amend, Judge, we'll go.
No, it's okay. I have to do, it's the numbers are the numbers. Okay. Count 1 in each of these cases alleges that you violated your probation by committing the offense of assault April 21st of 2025. And is that true or not true?
True.
And then count 2 alleges that you provided a urine sample April 29th of 2025 that tested positive for opiates in each case. Is that true or not true?
True.
2. And then count 3 alleges that you failed to provide verification of attending the JCDI program. Is that true or not true?
True.
And that's in each case as well. Count 4 in each case alleges that you failed to abstain from the use of any and all intoxicating substances, and that you tested positive for alcohol April 15th of 2025. Is that true or not true?
True.
And that's also in both cases. Count 5 in cause number 1829063, and count 6 in cause number 1828800 alleges that you committed the new offense of possession of a controlled substance May 29th of 2025. Is that true or not true?
True.
Is that enough for everybody?
Yes, Judge.
Sorry. I feel like I've gotten through it without messing up, but if I keep going on the different numbers. All right. Did you enter your pleas of true in each of those cases freely and voluntarily?
Yes, ma'am.
And because those counts are actually true.
Yes, ma'am.
In both of those cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Burbank?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
I understand.
State tenders number 1 in each of those cases.
It's 1.
It's admitted in each of those cases. Is there any evidence that Mr. Byerly is not competent? All right, Mr. Byerly, in each of those motion to revoke your unadjudicated probation cases, I am going to find that you entered your pleas of true freely and voluntarily. And cause number 1829063, find counts 1, 2, 3, 4, and 5 true, find sufficient evidence to find you guilty, and at this time find you guilty of violation of a protective order, sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And cause number 1828800, find counts 1, 2, 3, 4, and 6 true, find sufficient evidence to find you guilty, and at this time find you guilty of violation of a protective order. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Bless you. Give me just a second now. to, and did I print two?
Yes, ma'am.
Okay. Now let's go to. Okay, now, Mr. Byerly, in cause number 25 DCCR 0943, you're charged by indictment with a third-degree felony offense of possession of a controlled substance from May 29th of 2025, and how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? In that case, I also have here on the computer some documents that have your signature on them. Did you go over these also with Mr. Burbank?
Yes, ma'am.
And do you fully understand them? And you understand if I follow this agreement, you will also be waiving or giving up any right to appeal.
Yes.
Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tender's number one in that case. It's admitted. Mr. Byerly, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of this plea. Find sufficient evidence to find you guilty, and at this time find you guilty of possession of a controlled substance. Sentence you in accordance with your agreement to a term of 5 years in the Institutional Division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These 3 cases will all run concurrently, which means together at the same time. I have handed you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Burbank. All right, good luck to you, sir. Thank y'all. Thanks for your patience for me getting through that. Okay. All right, sir. Are you Lawrence Jackson? Are you sick right now, Mr. Jackson?
No, ma'am, I just said that.
Yeah, pull it down so I can hear you better for now. Thank you. And Mr. Jackson was previously in court in cause numbers 24 DCCR 1669 and 25 DCCR 0189. Entered pleas of guilty on each of those cases of driving while intoxicated, third or more. I've received the pre-sentence report. Has everyone had an opportunity to review the report?
We have, Your Honor.
Yes, sir.
Are there any additions or corrections?
No, Your Honor.
Not from the state.
No,
I guess this is just somewhat lucky because one happened before the other one was. All right, Mr. Jackson, I'm going to follow the agreement that you made with the district attorney. I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily. I'm going to find sufficient evidence in each case to find you guilty. In cause number 24 DCCR 1669, find you guilty of driving while intoxicated, third or more. Sentence you in accordance with your agreement to a term of 10 years in prison, but I'm going to probate that. You'll be on probation for 10 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation, which includes entering and successfully completing the safety program. In cause number 25, DCCR 0189, also find sufficient evidence to find you guilty, and at this time find you guilty of driving while intoxicated. Sentence you in accordance with that agreement to a term of 10 years in prison, but suspend that, place you on probation for 10 years. You're also ordered to pay a $500 fine in that case and follow all of the rules and conditions of probation, including entering and successfully completing the safety program. If you do everything that you're supposed to on these probations and you're successful, then for all practical purposes, your case here in court is over. You'll be able to serve that 10-year sentence while you're out on probation. The other side of that, though, is if you violate any condition of probation at all, you can be brought back into court and you can be facing that 10-year sentence that you've already agreed to. Do you understand? I only have one I don't know if y'all can get to it. I need the certification in 1669. I'm going to hand you the trial court certifications in each case that shows that these were agreements that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. It's okay. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you, sir, and we'll get that other copy in a little bit. Good morning. Are you Almeida Miles? And Ms. Miles was previously in court, entered a plea of guilty in cause number 24, DCCR 2330, to tampering with physical evidence. I've received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, sir.
Are there any additions or corrections?
No, no, we're good.
In addition to this pre-sentence report, I've also received and reviewed a number of jail incident reports. Has everyone had an opportunity to review those? And you're 19? Why haven't you been acting right in the jail?
Most of the reports are not true. One time I did not uncover my face on video. I did, because I was asleep, and she didn't wake me up. Ms. Boa didn't wake me up. When I got here in June.
So she's lying when she says she tried a few times, and then she taps you, taps your bed, kicks your bed a little bit,
That
and
day, Ms. Boa never tapped me. And then in June, I got in a fight when I first got here. The girl swung at me first.
okay.
That's accurate what it says, the girl here with a closed fist.
Yeah, I mean, if you get hit first, that's not the one that I'm so worried about. It's the, eating at your bunk when you're not, I mean, it's not even big stuff. It's just not following the rules. And if you can't follow the rules in jail, why should I believe that you can follow the rules on probation? When you're in jail, when you're on probation, when you've committed a felony, you don't get to make certain decisions for yourself anymore, right? Now, you're not going to be like every other 19-year-old and get to just do what you want when you want. You're going to have to do what either jail says or what I say or anything like that. If I'm going to follow this agreement based on the nature of the offense and based on the age and all of this, we're going to get you some help up front to be making better decisions. Otherwise, I'm not going to follow the agreement. Things could be a whole lot worse. Do you understand? So what I'm going to do is find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney, and I'm going to defer all proceedings and place you on probation for 10 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. One of those is going to be that you enter and successfully complete the cognitive track of the ISF program. That's a 90-day program. You're not going to get out of jail today. You're going to go to ISF instead, and you're going to hopefully pay attention and learn how to make better decisions. You're still young, you're still immature, but you're going to have to make some very mature decisions if you don't want to go to prison. And that's going to be to help you make those better decisions. Now, here's the thing. If you're in our jail and you start before they send you in the next week or two, or if you're in ISF and you are acting up and not following rules, putting something on your head that you're not supposed to, eating where you're not supposed to or when you're not supposed to, talking about whatever it is, I don't care, then you could be revoked just for not following the instructions. And you'll never get out and even have an attempt at probation. Do you understand? So whatever's going on and whoever your buddies are in there, you need to tell them, just sit there, do everything you're supposed to do. All the playing around's done because you want to get out and make something of your life. And if they don't want to, that's going to be on them. If you keep doing all this, you're going to have a felony conviction and you're going to go to prison. It's that simple. You understand? The part of this probation that is so good is that you don't have a conviction right now. And if you're successful and you complete your probation, you are never going to be a convicted felon. So this is a great opportunity. But if you do violate in any way, you'll be back in here, you'll be a convicted felon, and you could go to prison anywhere in that range of punishment, which is between 2 and 10 years. All right? I've handed you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. Good luck to you. You can go back with the bailiff. Okay, you're Gabriel Smith, and this is 25 DCCR 0979. There was originally a plea for a cap of 5 years that I rejected. There was new plea entered of a cap of 8 years, and we reset it for sentencing just for you guys to get anything together that you needed. I did not order an updated report or anything just because she's been in custody. And so is everyone ready to go forward with sentencing?
That's right. I think it's an 8-year cap.
What did I say?
8 years.
Oh, 8-year cap. Yes, I'm sorry. And so, Mr. Kimler, you may proceed.
Your Honor, the court previously refused a 5-year cap, so I'd say the court's probably inclined to give her somewhere between 6 and 8 years on this. I think Ms. Smith recognizes the error of what she did. She's attempting to try to remediate that in her own thinking. I understand she is going to have to do some time on this, but I think that she regrets what happened and hopefully not engaged in the type of conduct that caused this to occur. It was a theft case that went awry when the officer was attempting to stop her. She didn't really approach the officer and initiate some sort of contact with him. It was an unfortunate incident where, and I'm not contesting her culpability for her guilt, but where the officer reached into the vehicle and the vehicle moved forward, injuring the officer. So, yeah, obviously, if the court repeats 5, the court's inclined because of her criminal history to go to 6 to 8. We would just argue for 6 at the lower end. I know she has extensive criminal history, but she wanted to address the court as well. Is that right? You have to say who said it.
I apologize for the situation that went on, and I wish that anybody that was involved in the case would see that I'm overly serious and to whatever you give me, I thank you for that.
Okay, thank you. Ms. Malvino?
Judge, I think 8 is probably still too low based on the criminal history, but I would agree with Mr. Kimler that the underlying nature of the offense started out as a simple shoplifting case. It obviously went well awry. She could have injured the officer even more so. That being said, in combination with her criminal history, it's not simply just a shoplifting case, and I think she deserves, at the very least, a full rate.
So, Ms. Smith, the thing is, your theft convictions they start back in, it looks like 2007. And you've got a full page of misdemeanor, well, page and a half of misdemeanor thefts on this pre-sentence report where you were put in the parish jail. And then you proceeded to keep doing it, so they started adding up to felonies. You had probations that were revoked on 4 different theft cases that were misdemeanors that ended up as felonies that ended up with you going to prison. 5 years was, it looks like you got 5 years in 2016, 3 years in 2017, and then another year in 2018 in prison for the same thing, shoplifting. And this one, you're shoplifting and you end up climbing in your car, and I mean, just what went on with you and that officer is ridiculous, because you're trying to steal again, and now you end up hurting an officer in the process of them trying to stop you from stealing again. I'm going to find that you entered your plea of guilty freely and voluntarily. find sufficient evidence to find you guilty, and in cause number 23, DCCR 1034, find you guilty of robbery, sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. You do receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am going to hand you the trial court certification that shows this was an agreement I followed, so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Be sure to read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about it or how long it lasts, you can talk with Mr. Kimler.
The wrong case number.
I did.
You went on the robbery and we actually entered the plea on the assault.
Sorry, 25 DCCR 0979
That's the assault.
finds you guilty of assault. So I will withdraw the finding of guilt on robbery, find you guilty of assault on a peace officer. And all of the rest applies as far as the sentence and the cause number, again, 25 DCCR 0979, correct? Thank you.
I just say on the record, she wanted to make sure it's not aggravated. This is not aggravated.
No, it's non-aggravated.
Okay.
All right. And we have to have that discovery certification today because the case is going to get to close
Not
down.
again, you never gave it to me.
Well, I mean, the first, when she first pled.
So do I?
You didn't give
You
it.
to give me a
Still got the credit for me being in here on this.
Yes, all the credit that you were in, any time that you were on this case and there was a hold on you or you were in our custody, you get credit. Okay?
Thank you.
Good luck to you. Good morning. Are you Latrick Williams? Speak up. And Mr. Williams, it looks like you've got 3 cases, 2 motion to revoke probations, 1 for evading arrest or detention with a vehicle, 1 for theft of a firearm, and then there's a new case that's been indicted for tampering or fabricating physical evidence. And it's my understanding that Ms. Holmes has let me know that your family is going to try to hire an attorney. Is that correct? So are you asking me to reset your case to give your family some time to do that? Okay, so what I will do that. Mr. Williams, I'm sure you have heard, surely, out there by now, that I get copies of these jail incident reports and how you're acting and what you're doing. You think your family knows this when they're going to try to put up some money to go hire you an attorney? Do you think they know how you've been acting out in our jail? Do you? Do you think they know you've been masturbating in front of the correctional officers out at our jail? Do you think that they know that you're telling them to do their job and you're not going to follow their rules? That you're dashing other inmates with your urine, water, and possibly other items? I would guess other items would probably be something more disgusting than what I've already said, that you're walked up and punched someone in the face so hard that they had to go to EMS, had to come get them. You think they know all that? Should I keep going? Because on those motion to revoke your probations, I don't have to accept any agreement that this lawyer or any lawyer talks to that district attorney about. I don't have to accept an agreement. If I find that you violated your probation, I can sentence you anywhere in the range of punishment. That's what happens when you sign up for probation. If you violate, it's up to me. Sometimes I take deals, sometimes I don't. If you're acting like this, it's very unlikely that you're going to come in and some attorney is going to say, come on, let's give him one more chance. He's a good kid. He's got family. That's great that you've got family, but they don't know how you're acting. And obviously, you're not staying home and doing what you're supposed to while you're on probation. They can only do so much to help you, but you got to grow up and help yourself. If you go to trial on that new case and you're found guilty, a jury will hear all of this. So what's happening out there doesn't stay out there. Everybody finds out about it. And all it does is hurt you. Do you understand? So my suggestion is, the next time you're in court, I don't have a packet this thick of things that you've been doing out at the jail. Because your other attorney, whether it's her or they hire somebody, they're going to have to deal with this. And you can ask anybody. This kind of stuff is not going over well anymore in here. Those people are just trying to go do their jobs every day. They're going to work, going home. They've got families. They don't deserve this. Y'all acting like a bunch of heathens out in the jail? I mean, it's ridiculous, okay? All right, go back with the bailiff. I'll reset the case. Good morning. Is it Darius? Is it Valier or Valier? Valier. Oh, okay. And will your client waive the formal reading of the motion?
He does.
Mr. Valier, in cause number 17-27164, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation June 26th of 2017 for the offense of engaging in organized criminal activity, and that was a 4-year deferred probation. Is that correct?
Yes, ma'am.
It alleges that you violate, and obviously the years don't look like they match up, but this was filed back in, the motion was filed in 2022, so that would toll the time. All right, so it alleges you violated your probation. Count 1 alleges that you failed to report as directed to the probation department December 28th of 2021 and January 19th of 2022. And how, is that true or not true? True or not true?
Yes, ma'am.
Listen to the question. Thank you. Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true?
True.
Count 3 alleges that you provided urine sample October 29th, November 1st, November 3rd, November 5th, November 8th, November 10th, November 12th, November 15th, November 17th, November 19th, November 22nd, November
Judge, we can-
24th, December 1st, December 3rd, and December 6th of 2021 that tested positive for tetrahydrocannabinol. And is that true or not true?
True.
Judge, in light of our agreement, we can drop the remaining counts if it's all right with the court.
Let's see what we've got here. No new offenses.
No, Judge, he, after all those positives, he was ordered to go
To ISL.
to ISF, and he never did. And his explanation for his absconding that I was given by probation was that he moved in with his girlfriend and tried to ignore it, I guess.
Okay.
So that's why we're here today.
All right. Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily? And did you plead true to those counts because they're actually true?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Valier is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of engaging in organized criminal activity. Sentence you in accordance with your
Thanks for
agreement to a
watching
term of
this
10
courtroom
months in the
breakdown.
state jail prison.
Cases like this show how quickly repeated probation violations can escalate into serious prison time when court orders are ignored. If you found this case interesting, make sure to hit the like button, subscribe to the channel, and turn on notifications so you never miss our latest courtroom coverage. We post new real courtroom stories, sentencing hearings, probation revocations, and true crime cases every week. We'd also love to hear your opinion. Do you agree with the judge's decision in this case, or do you think another chance should have been given? Let us know in the comments below. And before you go, check out another courtroom video on the channel where a defendant's actions in court completely changed the outcome of the case. Thanks for watching, and we'll see you in the next one.